All right, hello everybody. Thank you for joining us today for the fourth row session. My name is Sarah Saunders and I'm a grant manager for the Human Services Department for the City of Savannah. And I'm joined today by Alex Taylor, Senior Grant Analyst, who will be assisting us with questions today. So again, if you could please enter your questions in the chat section, she'll assist us in getting those answered throughout the presentation. Now, some of you may remember in the beginning of the year, we conducted a capacity assessment of all of our agencies, and the topic of human resources and employment law was identified as a training need. So today I'm excited to introduce you to Mr. Bill Bruner, who is an attorney and a SCORE mentor, who has years of experience in the realm of labor, employment, litigation, and commercial law. Mr. Bruner has created employment contracts, confidentiality agreements, employee handbooks, HR policies, discipline and discharge policies. He's advised on HIPAA, employee benefits, and conducted sexual harassment training. So we appreciate all that Mr. Bruner brings to the table, and we certainly appreciate his time today. And we look forward to his presentation on employment law. So with that, I will turn it over to Mr. Bill Bruner, and he can take it away.
Good morning, everybody. Hope you guys are doing okay, and hope you'll be able to withstand the upcoming hurricane coming through. They say that legal problems are a little bit like a hurricane, because when you get sued, it's like a hurricane coming through. And afterwards, you just look and see how much damage has been caused. But regardless of the scope of the damage, it's been severe, it's been significant. And in a lawsuit, you still got to pay your lawyer. So it's a good idea for everybody, whether you have lawyers or not, to have a basic understanding of what the law is so that you can minimize the risks that your organization can incur. I don't pretend to be able to give you enough in the time we have available today for you to become experts in human resources or even labor and employment lawyers. But what I do want to do is to give you a flavor for what types of things are an issue, what types of things are not an issue, so that you can prepare accordingly. Before we get started, if you could please sit down and put in the chat for Alex to pick up what specific questions you'd like to have answered from me today. What issues do you have? What things are you looking for to get out of this today? And I'll either answer your question or make an opportunity for you and I to talk privately to get some more answers, okay? But take a minute now at your leisure and put down a chat exactly what you're looking for to get out of this. So labor and employment law, what every business owner needs to know to stay out of trouble. Okay, first, who am I? I am a mentor with SCORE. I'm retired. I used to be a corporate attorney with Black & Decker, been practicing law for over 40 years. My expertise is labor and employment and benefits. And yes, if you want to know what the UK pensions law is, I'll be happy to tell you, because I was a trustee to a UK pension plan for 30 years. SCORE is what I do now. I'm a volunteer with SCORE. I volunteer just like you guys do. SCORE is a 501c3, just like your organizations are. We are the largest provider of free business mentoring services and educational programs for small businesses in the U.S. And we have a team within our Savannah chapter that just does nonprofits. We have over 10,000 volunteers in the United States, over 4 million hours of mentoring services each year. You guys getting the screens okay? Good. We have over 45 mentors just in the Savannah chapter, and we've gotten all kinds of awards. This is what we do. This is our mentoring methodology. We don't tell you how to run your business. We don't tell you what will make it good, bad, or indifferent. We listen, we analyze, we test, and we give you ideas. And this methodology applies whether you're for-profit or not for-profit. We provide tremendous resources in our library at score.org. I'd encourage you to go there. The resources are free. The articles are free. You can also go to the Savannah chapter, savannah.score.org. You can find a mentor who will have particular expertise you're looking for. And of course, I'm a mentor. You can always come to me if you need some help. And these are some of our clients. You know Parker's, Rancho Alegre, Foxy Loxy. These are just some of our clients that you may be familiar with. But we have nonprofit clients too. And I have several nonprofit clients. I have a child placement agency in Brunswick. I've got another company that I don't want to mention because, by the way, all of our clients are confidential, right? We don't divulge information from what clients tell us. It's all confidential communication. So I'm going to talk about independent contractors or employees before I talk about what law applies to employees. But before I even get to this, let me talk about volunteers. You know, when I give this workshop for-profit businesses, they don't have many volunteers, okay? But you guys all do. You all have volunteers. Some of you have employees and some of you don't, but you've all got volunteers. And there are very different rules for volunteers than for employees. Some of you may be in a situation where you have volunteers who are doing work that could be classified as employment work. Some of you may have volunteers who you're looking to compensate from time to time. What are the rules? What happens if you break the rules? Let me take a minute. It's not part of the written workshop, but let me take a minute to talk about that, and we can come up with more detailed information later. But basically, there's a volunteer service rule of 3. A true volunteer are those people who first work towards the public service, religious or humanitarian objectives. You all satisfy that. You're in nonprofits. Secondly, they do not expect or receive compensation for services. Well, let me stop there. Do your volunteers sign a piece of paper when they start working for you that says that they recognize they're volunteers? They recognize they're not entitled to compensation? If they don't, maybe you should consider having them do that so that there's no expectation a year down the road or 2 years down the road after they put in umpty hours, I should have been paid something for all my work. Now, here's the third part of the rule of 3. They do not displace any genuine employees. Do not displace any genuine employees. So as you grow and you get bigger and you have both volunteers and employees, you're going to have to make sure that you have rules for volunteers that are separate from rules for employees. And you don't have volunteers doing employee work and employees being asked to volunteer for so-called volunteer work, okay? You need to make sure there's a clear distinction there. Now, what happens if you pay a volunteer? Well, the IRS says that a nonprofit employer must treat payments to volunteers the same way it treats payments to employees, which means income tax and FICA contributions have to be withheld. Living allowances, stipends, in-kind benefits are generally treated like wages too. So be careful about compensating volunteers because you may inadvertently cause them to become employees. Now, what is the difference for a volunteer? 2 big differences for a volunteer. If the volunteer gets sued because they're dishing out food at a food kitchen and somebody says they got poisoning, there's a federal statute for volunteers that provides them with immunity from protection. But guess what? If they're employees, there's no federal statute. So who do they sue? They sue the employee, who's now an employee, not a volunteer. And guess what? They sue you too. Okay? So that's a big consideration for the volunteer. All of a sudden, they're no longer a volunteer, they're an employee. They are personally liable. Now, they may sue you in turn, but they are personally liable. What's the second difference? Second difference is what happens if the volunteer gets hurt. If a volunteer gets hurt on the job, they can sue you if you were negligent. But if they're not a volunteer, they're an employee, their sole remedy is workers' comp. So there's a big difference for the volunteer in those two situations. So for those of you who are thinking, I can sleep through this because I don't have employees, I don't have to worry about it. Don't sleep, wake up. Now, you've got people that you want to do work and you want to pay them. The easy thing to do is to classify them as an independent contractor. Then you don't have to worry about all this crap I'm going to talk about. Can you classify them as an independent contractor, or do you have to treat them as an employee? Well, the answer is it's a legal determination. It's not a matter of your choice. An employee is a person who is hired by an employer to do a specific job. The terms of employment are specified in an offer letter, an employment contract, or union contract. The employer determines when and where the individual will perform their duties, and the employer provides the tools or other resources necessary for the individual to perform their duties. That's the classical employee situation. Okay, who's not employed? Volunteers, we just talked about that. Unpaid interns. You may have students who, as part of their high school or college education, may get credit for doing work, and the law says that you don't have to pay them. Owners, if you've got a small business and you're owner, you own your own small business, you're obviously not an employee. You get paid from the business that you own as part of the profits. And then lastly, an independent contractor. Typically, an independent contractor, the employer only has the right to control the result of the work and not the means and method of doing the work. So if you want somebody to paint your house, right? You hire a painter. A painter comes out and gives you an estimate. Says, I'm going to paint your house for $1,000. Fine. You may tell them when to start the work. You may tell them when you need to have it done. You may have the right to say it's done properly, it's not done properly, but you only control the result. You don't control the means and method, okay? That's the independent contractor situation. So what happens if you misclassify? You say, I'm going to treat this person as an independent contractor. I'm just going to write them a check and that'll be that. Well, the IRS says that if they are in fact legally an employee, you are required to withhold taxes, both federal and state income. You're required to withhold FICA, which is Social Security and Medicare tax, and you're required to remit to the IRS the employer portion of FICA. And if you don't do that, then you are liable for those unpaid taxes. You're liable for the amount that should have been paid to the IRS. So it's a big deal for misclassifying. And just because you call them independent contractors doesn't make them so. There are three key factors that the IRS has identified to help you properly classify your workers. Three classifications. Again, we're talking about independent contractors versus employees. They are behavioral, financial, and type of relationship. Behavioral. Who decides when the work is done, where the work is done, the way the work is done? Who decides what tools or equipment are used, where to get the supplies of the equipment, and who's hired or assigned to help with the work? When I hire somebody to paint the house, we agree upon when the work is to be done and where it's going to be done. Obviously, it's my house, but I don't tell them how to paint. I don't provide them with the tools. Now, maybe I pay for his paintbrush, maybe not. I probably don't. As far as the paint, I may pay for the paint. We may talk about where he gets the paint, but I don't tell him what supplies or equipment to use. And if he decides or she decides to bring a helper, that's up to them. So that's a typical independent contractor, as opposed to I'm a painting company and I will assign you to where you're going to paint and when you're going to paint. And I'm going to supply you with the tools and the equipment. I'm going to tell you where to go, and that's going to be that. That's an employee painter as opposed to an independent contractor painter. Financial factors. How is the worker paid? Now, if I hire a painter, I'm going to pay him a fee that's agreed upon, or I may pay him time and materials based upon how many hours you put in, based upon the cost of your paint. That's how I'm going to pay. But if it's a painter employee, I'm going to pay him by the hour, by the week. Who pays the worker's expenses? Is it the worker, or do you pay it? Or do you reimburse the worker? What is the worker's investment? Okay, if I hire a painter independent contractor, that person's going to have their own facility. They're going to provide their own tools and supplies. But if I'm hiring a painter employee, I'm going to have my own shop, and I'm going to supply them with these tools and supplies. Does the worker make his or her services available to the market? Okay. If this person's only working for me and not working for anybody else, they're going to look an awful lot like an employee. But if they have their own business, if they're looking for other customers, that's going to make them look more like an independent contractor. Can the worker realize a profit or a loss? That painter that I contract with, he can lose money if he doesn't have enough painting jobs. But the painter that I hire as an employee, I got to pay him regardless if I have work for him to do. And he doesn't realize the profit or loss. So type of relationship. If you do have an independent contractor, it is a good idea to have a contract. That contract should say specifically, I'm hiring you as an independent contractor and not as an employee. I'm going to pay you and specify, I'm going to pay you, $50 an hour for each hour you work for me. Okay. And you're going to submit an invoice to me and I'm going to pay against that invoice in 30 days. And specifically in my contract, I'm going to say, you will be responsible for all federal and state taxes relating to your work. And you're going to indemnify and hold me harmless if anybody comes after me because you haven't paid your taxes. So a written contract describing the relationship is really important. It's not going to be the be all and end all. If that person is really an employee, a written contract isn't going to make them an independent contractor. But in a close case, that's an important thing to have. What about benefits? If you're providing that worker insurance, 401k, vacation pay, sick pay, they're employees. They're not independent contractors. What's the permanence of the relationship? Are you hiring that person for a specific project or a time period or indefinitely? If that person's being hired indefinitely, that's going to look more like an employee. And last, the extent to which services performed by the worker are a key aspect of the regular business of the company. This is a hot button issue right now. It's a hot button in California in particular. Companies like Uber and Lyft, they provide drivers. The business of Uber and Lyft is to provide drivers for shuttling people from point A to point B. Uber and Lyft say that these drivers are independent contractors. But in California, California says no, the business is providing transportation services. They are providing transportation services. California says they must be classified as employees. Now, I have Georgia clients who are in similar positions, okay, providing, for example, translation services. Their business is to provide translation services. The translation services are being provided by independent contractors to my client. Are they legitimately independent contractors? The answer is, if she was in California, no, they're employees. But here, they're not. In Georgia, they're considered to be independent contractors. What's the bottom line? Bottom line is employers have to weigh all of these factors to determine whether a worker is an employee or an independent contractor. And no single factor or set of factors makes the worker an employee or an independent contractor. you have to classify your workers properly. Questions about independent contractors?
We don't have any questions in the chat about independent contractors or versus employees, but our first question that came in was the difference between an employee and a volunteer. So I feel like you covered that really well. Our second question that they'd like to see covered is basics for nonprofit HR with a staff of 10 to 15 and volunteers.
Okay.
And then another request is that Dr. Robinson stated that Georgia is an at-will state. What are the legal cautionary measures that a nonprofit should know when firing an employee with or without cause?
Great questions. I'm going to cover those in the session today. And if I don't cover them, you bring it up at the very end, okay? But I've got them. So you have an employee. What are the legal rules regarding employing those people? And I'm going to talk about statutes. I'm going to talk about federal and state laws. And I'm going to tell you whether you're covered or you're not covered. But when I tell you whether you're covered or not, bear in mind that you can agree by contract to be covered by laws that you otherwise would not be covered by. The terms of grants, both state, local, and federal, may require that you comply with laws that you otherwise wouldn't have to comply with because you're too little. So let's talk about, for starters, the Fair Labor Standards Act. This is a federal law that applies to all businesses that are in interstate commerce and have revenues of $500,000 or more, or they affect interstate commerce. And if the terms of affecting interstate commerce are quite broad. If you're covered by the Fair Labor Standards Act, you have to pay minimum wage. Now, minimum wage in the state of Georgia, if you can believe it, is only $7.25 an hour. Because Georgia has not enacted a minimum wage statute like most other states have. There's an even lower requirement for tipped employees. Can you believe that the federal law says a tipped employee has to be paid at least $2.13 an hour? Okay, that's federal minimum wage. Of more concern for you should be the overtime pay requirement. Federal law says that you have to pay overtime for people who work more than 40 hours in a work week, unless they are exempt. That means that if they work over 40 hours, you pay them at a time and a half clip. So if their base rate of pay is $20 an hour, then overtime has to be paid at $30 an hour. That's 40 hours in a work week. That's a 7-day work week. That applies if they are non-exempt. Who is exempt? Managers, supervisors, technical, administrative people. Those are classifications which are not exempt, and you can require them to work over 40 hours. But that's not the end of it. You have child labor requirements. Federal child labor law says that you cannot employ someone under the age of 12. You have to get a work permit from school if they're under the age of 16. They can't work between 9 p.m. and 6 a.m. and so on and so forth. A lot of details. Also details in terms of what they can have access to. There may be machinery or equipment that they are not allowed to work around. I used to work, before I retired, for Black & Decker. We had children who wanted to work for us in our service centers. They could not work in our service centers because we sold power tools. And we didn't just sell power tools, but we repaired power tools. They weren't involved in the repairing of power tools, but because our facility involved the repair of power tools, just regular power tools that you'd use at home, they were not allowed to do it. So if you have children, and by the way, that would apply to volunteers as well, okay? If the Fair Labor Standards Act applies, you can't employ children or have volunteer children at certain hours in certain occupations. And last, and I didn't mention this here, is record keeping. if you're under the Fair Labor Standards Act, you have to keep detailed records of hours worked, wages paid, the whole 9 yards, okay? If you have somebody doing your payroll for you, they would know what the record keeping requirements are. But just bear in mind, it's based upon law, not just based upon good business practice. Safe workplace. The Occupational Safety and Health Act is a federal law. It applies to companies with 100 or more employees. You may remember the brouhaha over COVID-19 testing. The way the federal government was able to enforce that was under OSHA. That was their legal basis for enforcing the vaccination requirement under OSHA. And I'll talk more about what OSHA requires later. Employees have a right to organize under the National Labor Relations Act. Not only do they have a right to organize, but they have a right to communicate information with each other that may lead them to decide to organize. So people talking at the informally about wages and hours and conditions of employment, you may not like that, but they may have a legal right to do that under the NLRA. Freedom from discrimination. Title VII of the Civil Rights Act of 1964 applies for employers with 15 or more employees. It prohibits discrimination on the basis of race, color, religion, creed, national origin, or sex. And I'll talk later about both direct and indirect discrimination. But if you're less than 15, it doesn't mean you don't have to be worried about it. Because if you have a grant, or if you have a contract that's a state, federal, local contract, you may be required to avoid discrimination in your employment. And I'll talk specifically about what that means. There is a Federal Age Discrimination in Employment Act, ADEA, which applies if you have 20 or more employees. And that says you can't discriminate against people on the basis of age if they're over the age of 40. The Americans with Disabilities Act applies if you have 15 or more employees, and it requires, there are provisions that apply to employment, and there are provisions that apply to public accommodations. So with employment, it means that people who are disabled have to have access to submit an employment application. They can't be refused employment simply because they have a disability. And it means you have to make a reasonable accommodation to disabled people. The public accommodations provisions means that your facility, if it is open to the public, has to be accessible. And I'll talk a little bit more in detail about accessibility. Immigration Reform and Control Act applies to employers with 4 or more employees. This law says that you must ensure that the people that you employ are allowed to work in the United States of America. And that means they have to have 2 things. They have to have proof of identity, that is, who they are, who they say they are. And secondly, they have to have proof of work authorization. That is to say that they're allowed to work in the United States. Okay. Proof of identity can come in several different forms: a birth certificate, passport, so on. Proof of work authorization can be Social Security card, a green card, a passport. And you're required under the Immigration Reform and Control Act to do 2 things. You're required to make sure that the people you hire have presented those 2 things. And secondly, you're precluded from discriminating against people on the basis of their immigration status. So if you're the CIA and you are required by law to only employ citizens, you can limit your employment to citizens. But other than that, you have to employ immigrants to the same extent as you employ citizens, and you can't discriminate on the basis of their status. So what are employee rights? One of the rights is workers' compensation. If you have 2 or even 3 employees, you're going to need to pay into the workers' comp system. And that is a plus and a minus. The minus is it's going to cost you money to pay for workers' comp. The plus is they don't get to sue you. If they get injured on the job, their sole remedy is workers' comp, unless it is an intentional tort. So if you shoot them, I'm sorry, it's not covered by workers' comp. You're going to pay the price. Family Medical Leave Act. If you have 50 or more employees, federal law says that you must provide up to 12 weeks leave in a 12-month period for the birth or adoption of a child, for a child's serious health condition, or a spouse or parent's serious health condition. That's a cumulative 12 weeks in a 12-month period. It does not require to be paid under federal law, which makes the US one of only a handful of companies and countries in the civilized world which does not require that it be paid. But the federal law does not require family leave to be paid. And lastly, a benefit is unemployment compensation. If someone is let go, they're entitled to apply for unemployment, and you're going to pay for that. You pay FUTA, F-U-T-A, as part of your wages that you pay, the deductions from the wages that you pay FUTA, just like you pay the employer portion of Social Security, which is FICA. You're required to have posters in the workplace, and here are sample posters. By the way, you do not have to have posters unless you have employees. A number of my clients get a scam email that says, you have to buy these posters from us because it's required by law. You only have to have posters if you have employees, and you don't have to have the ones that these guys are selling. So you've decided you're going to have an employee. How do you get started? What is the hiring process? You don't have to have an employment application, but I strongly recommend that you have one. That employment application should have basic information that I'm going to describe in a minute. But who do you have to give the application to? Who must you consider? Well, these are the protected classes. These protected classes means you cannot just exclude these people on the basis of their classification. Now, you'll see that in addition to the ones that I mentioned above, there's veteran status and LGBTQ. So where did that come from? There's a federal law, the Vietnam Veterans Readjustment Assistance Act, which provides for protection for veterans generally. And LGBTQ, the US Supreme Court has ruled that that is a form of sex discrimination, to discriminate on the basis of sexual orientation. So that should be considered in the same classification. Now, these are federal laws. We're not talking about state laws. We're talking about federal laws. The employment application, it should be written. I would suggest that you have a written form employment application. I would suggest that every person who wants to work for you be required to fill that out. Even if you know you're going to hire them ahead of time, get them to fill out the employment application. Get them to complete it and get them to sign it. Why is that important? Because if anybody comes back and says, why didn't you hire Jill? You have an employment application which has written basis for it. If somebody says, I was rejected for employment, and you don't even remember that they came to you, and you don't have a policy that requires employment applications, it's your word against them. If your policy says that you're always going to require an employment application, then you're going to be doing yourself a service by making sure that everybody fills one out. Now you've decided, you've picked up the applications and you've decided you're going to interview folks. How do you determine who to interview? Well, you determine who is best suited for that position. You should have a job description for that position. You should be able to communicate the job description to those people so they know what you're looking for. And in the interview, you're going to ask about questions which relate to their ability to do the job. So questions that focus on their ability to perform the specific tasks, duties, are relevant and they're perfectly permissible. So what would you do if this happened? Tell me about a time in your career when this happened and how you handled it. If it's a manual job, it's perfectly okay to say, the job involves doing this. Show me how you can do this. Okay? Job relevance is going to be permissible and is the best type of question to ask. What is not permitted? You can't ask questions that directly relate to a protected class. Race, color, religion, creed, sex, age, national origin, disability, veteran status, LGBTQ. You can't ask them directly. But sometimes it's going to come up and you better be prepared and know what to deal with, how to deal with it. So you're interviewing somebody and you say to them, is there anything that would prevent you from being able to do this job? And they say, I am a reformed drug addict. Is that going to prevent me from taking this job? And you, as the smart employer who know that a reformed drug addict is a disabled individual because they have a history of a substantial limitation in work activities, you're going to say, oh no, Ms. Jones, the fact that you're a reformed drug addict will not preclude you from working for us. So what happens next? They don't get the job and they sue you. They say, it was really on the basis of my disability. But you're going to win that case. First, you didn't ask about it. Secondly, you gave the right answer. And third, you took good notes of your interview so you can show what questions were asked and how you answered them, okay? And it's not just questions that directly relate, it's questions that indirectly relate. So you're hiring a financial manager and you say, oh, gee, I see that you attended Georgia Southern and graduated in 1987. What's the problem with that? Any problem? Well, if they graduated in 1987, chances are they were probably, let's say, born in 66. If they were born in 66, that would make them 56 now. 56 is over the age of 40. It's in the protected age bracket. And if you end up hiring a finance manager who's 26, maybe they sue you for age discrimination and they say, you knew my age because you specifically talked about when I graduated from college. So you need to be careful. And I use that as an example of when they graduated from college, but it could be something even more subtle. Maybe they pledged a fraternity in college that's an all-Black fraternity. Okay, I mean, you just have to be careful in the questions that you ask. So you've been through the questions, you've decided who you want to hire. What kinds of pre-employment testing, screening can you do? First question is drug and alcohol tests. Can you do drug and alcohol tests? The answer is yes, you can. You should give them after a conditional offer of employment, which I'll talk about in a minute. And you should do it through a certified laboratory where you use proper chain of custody and collection procedures, where they sign a piece of paper which indicates what drugs that are lawful drugs they're taking. Make sure you do it right. Okay. I put in the drug testing program at Black & Decker. And so I can tell you that if you do it right, it's perfectly defensible. Background checks. by all means, do background checks. First thing you should do is Google, all right? Google them, look at Facebook, look at LinkedIn, look at their social media, find out what you can about those people. They can come back later and say, oh, well, you had no reason to do that. You invaded my privacy. Baloney. You have no rights of privacy with regard to what you put on the World Wide Web. I'm sorry. It's there for anybody to find out. Okay? Do your homework. Find out about those folks. Now, I'm not saying you make employment decisions on the basis of it. I'm saying you find out as much as you can. So preferably you do that before you hire those candidates, right? So you're hiring somebody and they're, let's say, 40 years old, and in their Facebook profile, it shows that they were, when they were in college, they were experimenting with drugs. Does that mean you don't hire them? No. What it means is you ask a couple questions about that. Okay? Ask them some questions. I'll never forget, I had a phone call from an HR manager saying, this lady applied for work for us, and she's just got out of prison for murdering her husband. Do we have to hire her? Now, what job was she applying for? She was applying for a assembly job in the workplace, right? So I said, what is her record otherwise? Is her work record otherwise fine? Yes. Have you interviewed her? Yes. What has she said about the murder? She said he was an abusive husband, and that's why I'm out now, because they reduced my time because he was an abusive husband, and I'm reformed now and I want to get a job. I said, then hire her. Even though she had been convicted of murder, that's not a reason to not hire them. Okay? So when I say do background checks, I'm not saying if you find something bad, you don't hire them. Just that you look and you find out. What about credit ratings? I would suggest that you not go there. You can ask for them to waive their rights and give you credit information under the credit agencies, Equifax, and so on. And if they sign a piece of paper authorizing you to get that, and you decline employment on the basis of that, you then have to give them written notification that you were turning them down for employment on that basis. But I wouldn't go there, because unless you're talking about a job where handling money is a big, big deal, it's probably not worth the effort on your part. Okay? Pre-employment medical. The ADA says you can do a pre-employment medical if it's job related. So if you have a job that requires physical strength, physical agility, and so on, you can get a pre-employment medical. Again, they need to consent to it, but it costs you money. So think twice before you do it. Strength and agility tests, probably you should avoid, because guess what? They are going to discriminate indirectly on the basis of gender. More women are going to, statistically, are going to not pass those general tests. IQ tests, psychological tests, like AVA or Myers-Briggs, they're nice to know. They may be more suited for placement than for employment, but I steer clear of them because they may have an adverse impact on the basis of race or gender. Citizenship and immigration status, you can't prefer citizens to non-citizens, okay? So you don't want to be requiring that as a condition of employment. Arrest and conviction records, I touched upon that. Just because somebody has been convicted doesn't mean that you can automatically exclude them. Besides the fact that it may not be relevant to their ability to do the job, it can also discriminate on the basis of race, because minorities are more likely to have arrest records and conviction records than non-minorities. Same thing with high school diploma. Unless it's specifically related to their ability to do the job, a blanket high school diploma requirement is probably going to be prohibited as employment discrimination. So you're now ready to hire somebody. what do? You pick up the phone and you call them and you offer them a job. They say, great, when do I start? Is that all you do? No, you should have an offer letter. Now, the question asked about employment at will, and this is where you start the employment at will legal process. Your offer letter should specifically say that employment is at will, and what that means is, and you spell it out in your offer letter, that means that you can be terminated, your employment can be terminated at any time and for any reason, with or without notice by the employer. And you may resign from employment at any time and for any reason, with or without notice. It's reciprocal. That's what employment at will means. And your offer letter is going to say that. Your offer letter is going to say the general stuff: job title, responsibilities, rate of pay, start date, terms of employment. But any conditions to hire is specified here. So we talked about a drug test, we talked about pre-employment medical, we talked about proof of identity and work authorization. You're not going to do those things before the offer letter. You're going to do those things after the offer letter. The offer letter is going to say that employment is conditioned upon your passing these things. So the offer letter is critical to have so that you can protect yourself. Now, what happens if you don't have an offer letter? Well, what happens if you don't have an offer letter is you had an interview with this person, you told them they were great, they love hearing you telling them how great they are because you've offered them a job, and they say, well, what's my future like at the XYZ company? And you say your future looks great, you're a great person, you're terrific. Well, would you be firing me anytime soon? Of course we wouldn't. We only fire people if there's good reason. If you don't have an offer letter, guess what? You have an employment contract, a verbal employment contract that can only terminate employment for good cause. That's why you have an offer letter. Now, it's not required, but it's a good idea to have an employee handbook. Now, if you've got one employee, you don't want to do the trouble of an employee handbook. But if you have multiple employees, it's a really good idea to have a handbook. The handbook is going to be sort of like an employment contract. It's going to be the place that they go to find out all kinds of things about working for you. And it's going to be binding upon them, just as they expect it to be binding upon you. So you're going to have a signed employee acknowledgement. It's going to talk a little bit about you, your values. It's going to reiterate that employment is at will. It's going to talk about your policies on employment, non-discrimination, wages, timekeeping, benefits, any rights that you have, any benefits you have. It's going to talk about performance and promotion, opportunities for promotion. It's going to talk about health and safety, workers' comp, discipline. I'm going to talk a little bit about progressive discipline later. Complaints and dispute resolution. There will be times when there will be a problem in employment. How are those problems going to be handled? You don't want that person to just walk off the job disgusted. You want an opportunity to learn what those issues are and see if they can be resolved. So you might have an open door policy that says that even if they're working for somebody else in the organization, they can always go to the CEO or general manager, whoever it may be, to have their issues raised. This is where you have a non-compete. If you want a non-compete or a non-disclosure, you're definitely going to want to have a non-disclosure. If they are in a position to learn things about your business that you don't want to be known on the pages of the Savannah Morning News, you should have a non-disclosure agreement, and that should be in the employee handbook. Some companies have a separate non-disclosure agreement that they sign when they start working. If you don't have a handbook, you should have that. Non-disparagement says that they won't badmouth you when they leave. Also, what happens when they end employment? Okay, that would be exit interview, 2 weeks notice, what is your policy on that, and so on. What happens on their first day on the job? The first day on the job, they complete the tax withholding form, IRS Form W-4. In it, they indicate how many exemptions they're claiming. They give you a document which proves identity and a document that proves work eligibility. Now, some of you may have heard about an 800 number that you can call to find out if they're legitimate. Okay. So what you do is when they fill out the W-4, you will see they have to put out a social security number. You can then call that 800 number. You can say, Jane Jones, social security number, so-and-so and so-and-so. And they will tell you whether that's a match or not. That's handy, but that's not the be all and end all. Just because there's not a match doesn't mean you can say, okay, I'm not hiring you. Why? Because it's not always accurate. Why? How can it not be accurate? Well, if you're Hispanic, you may have a patronymic, and the last name may be a patronymic, or it may be your real last name. So my spouse might be Eloisa Fernandez Bruner, and in the Hispanic culture, she may be Eloisa Fernandez de Bruner. And so she might go and apply for a social security card as Eloisa Fernandez, which we would call a maiden name. All right. So the names don't necessarily match. So you can't just do the 800 number. It's not a complete solution. So they come to you and they give you proof of identity and proof of work authorization. And when you look at the form, the IRS Form I-9, you'll see there's all kinds of different documents that they can present to show that. They do not have to give you a social security card to prove work authorization. They can show a green card. They can show a passport. There are a lot of different documents that prove work authorization, just as there are documents that prove identity. They fill out this form. You look at those papers. The law says you don't have to make copies of those documents. The law says all you have to do is keep the I-9 form. My advice to you is make copies of those documents. Why? 2 reasons. Number one, if you think it's a phony document, how are you ever going to be able to prove that unless you had a copy of it? And secondly, if you think it's phony and they go to the Department of Justice and they come after you for discrimination, you have a piece of paper that you can show them as to why your fear was legitimate. The law says the I-9 form and the supporting documentation go in a separate file, separate from the personnel file. And by the way, you don't have to do this for independent contractors, but you do have to be wary of the law, because if you've got a whole bunch of independent contractors and they're all illegal, not non-documented aliens, you could still be in trouble for employing people in violation of the Immigration Reform and Control Act. So on the first day of the job, they get the employee handbook. They sign the acknowledgement if there is a handbook. If you have benefits for them, for each benefit plan, you should have a summary plan description, and they would complete benefit election forms. What do you withhold from the paycheck? There are required withholdings. You're required to withhold FICA and the Medicare tax. You're required to withhold FUTA, federal unemployment tax, federal and state income tax. There's also a portion that you have to pay as the employer. The self-employed tax, Social Security tax, is a different tax rate than what you do if you're an employee. Okay. What about permissible withholdings? If they're in a labor union, you can withhold union dues. benefit plan payments, obviously, you're going to have to withhold. 401k deferrals if they're in a 401k plan. What about other withholdings? Well, you should have a document signed by them to support any other withholdings. You may have, they may have to pay for clothing, for instance. You should have a piece of paper that supports the withholding for the clothing that they have to uniforms and things like that. All other withholdings are not permitted unless you have a written authorization. Promotions. This is something you would cover in your employee handbook. You have a choice on how you handle promotions. You can do it strictly by seniority, or you can do it by merit. If you have a handbook, it's a good idea to specify how you handle promotions. What about job vacancies? What if there's a position that's vacant in the company? You ought to consider having a job posting policy if you have more than one employee who could be considered. What you don't want is a situation where you just automatically pick the person that you think is best suited for that opening. If there are multiple people, you should give them an opportunity to bid. You say, well, I know who these people are and I know their abilities. How do you know unless you have a job posting? Let them bid and then interview them. You may find they have skills and abilities that you didn't know about. At the very least, it gives them the assurance that you're being fair and considering all possible candidates for any opening that comes up. Discipline. They don't show up for work one day, you just fire them, right? Well, that's what employment at will says. Employment at will says you can terminate them at any time for any reason, good, bad, or indifferent. They came into work with spiked red hair and that's not our dress code and you're out here, boom, gone. Okay. It's a good idea not to do that though. People aren't going to want to work for you if you exercise your legal rights to be completely arbitrary. Okay. People aren't going to want to work for you. So it's a good idea to have your rules in the handbook and to have progressive discipline for violating the rules. Now, obviously, if somebody steals from the company, you don't have to go through progressive discipline. You can terminate them. But if they're late for work, or if they have a attendance issue, you probably want to address that with something short of termination, like a verbal warning, where you sit down with them and say, what's the problem? Why aren't you coming to work on time? That's a verbal warning. It's a dialogue. You're talking to them. Guess what? They get to talk to you. And they say, my problem is my kid. My kid's got a substance abuse issue and I don't know what to do about it. Guess what? Now you have an opportunity as a good employer to be proactive. Okay. What resources are available in the community to help that worker of yours deal with their child's substance abuse issue? Okay. You have an opportunity to be proactive and help that employee instead of going blindly along the steps and ultimately discharge them because they're too much trouble. Okay. What's the benefit from that? The benefit from that is you're treating employees with respect and dignity, and they will reward you with their service accordingly. All right. So verbal warning, typically the next step is written warning. The next step can be suspension or pre-discharge warning, and lastly, termination. And at each of these steps, they're going to have an opportunity to have dialogue with you. You're going to be explaining to them what the implications are, so that by the time they get terminated, you and they will have exhausted all available means to a short of termination. So you have the legal right under employment at will to fire them, but you voluntarily agree to a progressive discipline because you want your employees to know that you're going to treat them fairly. Now, appeal rights is important. One of my facilities had a peer review panel. Even after the employer terminated somebody, they had the right to appeal to the peer reviews. This was obviously a large employer. So the peer review panel was a group of 3 or 4 people who elected to be on the peer review panel. And so the termination was appealed by the discharged employee to the peer review panel. And the peer review panel had the authority to overturn the company's decision. So you say, why on earth would any respective company ever do that? Well, if you can't justify your termination decision to 3 or 4 of your best employees, you don't deserve to be an employer. Okay? It's as simple as that. And if the peer panel upheld it, what happens? Now you don't have problems with the rest of the employees in the workforce who would normally side with that discharged employee and feel sorry for that discharged employee. The peer review panel, their own coworkers upheld it. Okay? So sometimes when you give up rights that you own, it can benefit you. Okay? Layoffs. When I say layoff, I'm talking about situations in which people are let go through no fault of their own. Funding has gone down. You can't afford to employ them. How do you do layoffs? Well, the employee handbook would be the source to tell people how you're going to do that. You have 2 choices. You can do merit or you can do seniority. Merit says you pick the person who is in the position that's affected and they go. Or if there's more than one person in the position, merit says I'm going to take the person who's the better performer, more valuable, longer service, and so on. Seniority is blind. Whoever was hired first has the longest tenure. Whoever was hired last goes out the door. If you lay people off, do they have recall rights? That is the right to come back to work when situations improve. You can lay off people with recall rights or without recall rights, but you have to decide before you lay them off. And you have to tell them whether there's recall rights. Typically, you recall in the reverse order of layoff. And lastly, and this doesn't apply to you, if you are a large employer, 500 or more employees, and you have a mass layoff or a plant closing, there's a federal law called WARN that says you have to give 60 days advance notice before you engage in that termination. Otherwise, it's employment at will, and you can terminate people at any time without any advance notice. Any questions so far? Anybody?
No, no questions yet.
Okay. OSHA. Workplace safety and working conditions are governed by a federal law called OSHA. OSHA has far-reaching implications. It requires that you have protective gear for positions where there's a risk of injury to themselves. Obviously, a person at a construction site has to have a hard hat, but there may be other protective gear that would be required. You have to have a material safety data sheet for hazardous materials that people may have exposure to. So you say, well, then that doesn't apply, you know, what hazardous materials? Well, I have a client who makes soap. Soap, makes it in his garage. How do you make soap? Well, lye and usually some kind of a fat. What is lye? Lye is sodium hydroxide. Is lye a hazardous material? Well, yeah. If you inhale it, it can affect your lungs. If you touch it, it can burn your hands. So you're required to have a material safety data sheet if you have contact with a hazardous material. And OSHA provides those MSDSs, as they're called.
Do basic cleaning supplies count towards the material safety data sheets?
That's a great question. It depends upon the label. If you're buying your cleaning supplies commercially, they're going to have all kinds of labels on them. And the labels will have skull and crossbones, and it'll say, don't mix this and this, don't mix this with that, ventilation, so on and so forth. Comply with those requirements. But generally speaking, you're not dealing with an MSDS, you're complying with the limitations on the cleaning supplies. And if you as the employer don't, you could be held responsible for that. Not just dealing with the workers' comp claim for somebody who's injured, but dealing with OSHA for an OSHA investigation for not complying with the OSHA rules on proper handling of hazardous materials. So I said the ADA has two sections. So I said it has an employment section and a public accommodation section. The employment section says that your facility has to be able to employ disabled people. That means they have to be able to come and fill out employment applications. Something as simple as filling out an employment application. So if your employment applications are accepted in your office and you can't get into your office, if you have a wheelchair, you got a problem. You're discriminating. You're in violation of the ADA. A person who uses a wheelchair has to be able to come in and fill out an employment application. And that means that you have to have it accessible for interviews and so on. It means that they can't be rejected for employment on the basis of this disability. And it means that you have to make a reasonable accommodation. So who is disabled, right? I touched upon this before. A disabled person is obviously someone who is blind or deaf or is using a wheelchair, but it's more subtle than that. Is a person who has bipolar disorder disabled? Yes. Is a person who is a reformed alcoholic disabled? Yes. They're disabled because even though they presently don't have a disability, they have a record of having had a disability. So a woman who's a breast cancer survivor is covered not only as woman by gender, but she's covered as disabled. Okay? So a disabled person, the disability defined as a substantial limitation in one or more major life activities. Has to be substantial, one or more major life activities. Okay? So what's the process here? You've hired this person. They have a hearing problem, right? They have a hearing problem. And they're going to work for you. And they're answering the phone, but they have difficulty understanding the person at the other end of the phone. Or they can't always hear what you're saying because they have to read lips and you're wearing the COVID mask. Okay? A reasonable accommodation is required. So what's a reasonable accommodation? Well, that requires an interactive dialogue. The employee and you and the employee's physician have to have a dialogue over what accommodation will enable them to perform the essential functions of the job. If they have trouble hearing, you may have to have a different kind of telephone, right? You may have to have one of those phones that has a connection to their hearing aid, which is Bluetooth. Okay. You may have to have it able to be louder. Okay. Or you may have to have a phone which has the captioning on it. Right. So all these things are potential accommodations, not necessarily any one of them necessary, but those things you would be exploring between you, the employee, and the physician. That's a dialogue. So who gets to pick what accommodation? The answer is ultimately you do. So if you have accommodations that would be really expensive, like every time the phone rings, I have to get somebody else to answer the phone and then tell them what's on the phone. That's not a reasonable accommodation. That's an undue burden, right? But what is really an undue burden? Well, the law says it depends upon how big your employer is. For a big company like SCAD, right? And SCAD has deaf students. SCAD has to hire interpreters who sign all the classes that the deaf students attend. That's what SCAD has to do. Do you have to do that? Probably not, because you're much smaller. What is an undue burden will depend upon the size of the employer. What you can't do is ignore it. You can't say, suck it up and deal with it. It's the phone. You got to learn how to use the phone. If you can't use the phone, forget it. So that's the employment piece. There's also the public accommodation piece. Okay. So
Mr.
you
Bruner?
have, yeah.
I have
Yeah.
a quick question relating to what you were just speaking on. If your building is not able to totally accommodate a person, can you deny them employment?
Give me a for instance. Tell me exactly what you mean.
It's not detailed further, but I assume something like wheelchair accessibility, and it's a house maybe that the program is out of, and it's only stairs. Would that be a situation where they can deny an employment?
Yeah, those are good examples. For example, yeah, like for instance, if you're not financially able to make the accommodation to the building, you just don't have the money to do it. Like you may have one interest that they could come in, but then maybe it's not the door's not wide enough for the wheelchair. You see, if they could come in that door and be on there with a walker, they could get in the building. But if they have to use their wheelchair, then that door, we can't get them in the building. So, and we can't afford to make any changes. So what do you do?
Well, that may be an example of an undue burden. I mean, I can see suppose your business is providing home care for the elderly, right? And you're providing it at their homes, right? You obviously can't change their homes. And if the person requires a wheelchair and they can't get into their homes, then it would be an undue burden to say you have to redo their homes. But if it's your place of work, now it's a question of whether you have to redo your place of work to make it handicap accessible. And if it's open to the public, not just to employees, but to the public, Title IV of the ADA applies. And it says, regardless of whether you have an employee who has a wheelchair, who has difficulty getting in, if the public at large can't get in if they use a wheelchair, you got a problem. Okay, because Title IV applies to you. So your facility should be handicap accessible. The parking spaces have to have a certain number of spaces that are designated handicap with proper curb cuts. If you have restrooms, you have to have handicap restrooms. So if it's your facility that you have control over, now all of a sudden you're looking at what constitutes an undue burden, and you may be required to do that.
So say it's roughly 10 students who attend a program in a home setting. Are these accommodations required in like a small setting such as that?
Are these students, it's the public, right? This is not employees we're talking about, just talking about public facilities open to the public. Is that right?
Yes.
Okay. Then if Title IV of the ADA applies, then you have to have your public facility accessible, whether it's 1 or 10 or 0. And even if there's nobody who is affected by it, you could still find yourself sued.
So let me ask one follow-up question. That is, well, if you're leasing the space, then who becomes responsible?
The answer is both. Both you as the lessee and the landlord. Both. I had that case in Tampa. We had a small service center. It had a service center manager and one repair tech, and it was in a strip mall. And we got a lawsuit claiming that there weren't sufficient handicap parking spots and that the front door was not accessible to a wheelchair person, and that the aisles were not broad enough for it to be accessible for a handicapped person. There was never a handicapped person who tried to get into our store. It was just a lawsuit. And who filed the lawsuit? A guy who was hired by a plaintiff's law firm who sued every other company on that strip of the highway. And after the lawsuit, they sent us a letter that said, pay me $500 and I'll drop the lawsuit. And because I'm an SOB, I said, screw it, we're not going to pay you $500. And he went away because he didn't have a lawsuit. But the point is, these laws apply even if you don't have an actual victim. So if you buy a facility, if you renew a facility, if you lease a facility, before you enter into a lease, you need to have this discussion with the landlord. And your lease with the landlord should say, this facility will be accommodating under state laws, the zoning laws, and under the ADA, and it will accommodate people. And if we get sued, you're gonna pay the price for the lawsuit. Don't take a facility that's not accessible to the handicap, because you could be sued. I said I would tell you what the law is. I didn't say you would like it.
Great information.
Okay. Payment of final wages. It's their last day of work. What do? Well, you have to pay them their final wages on the last day of work. It's not good enough to say, I'll send it to you in 6 months. Be prepared to give them their final paycheck on their last day of work. You're going to want to make sure that you get all property back from them that you've lent to them, which includes, ID cards. You're going to want to disable security and systems access if it exists. You're going to want to tell them the effect on employee benefits, such as COBRA, which is Comprehensive Omnibus Budget Reconciliation Act. It gives people the right to continue benefits if they pay the entire cost of those benefits. If they resign, you're going to want to conduct an exit interview. Now, why? What's the point? You don't have to do an exit interview, so why do an exit interview? For 2 reasons. First, this is your chance to find out what issues they have with the company. And they may have issues that they were reluctant to bring up ahead of time. And it provides a great opportunity for you to learn what things need to be fixed in your organization. I said there are 2 reasons. What's the other reason? The other reason is so you have a documentation that Jill quit. Jill quit because she had a better job, or whatever the reason may be. So why do you need that? Because if Jill doesn't find a job in the next 2 or 3 weeks and files for unemployment, you have proof that she resigned and you didn't fire her. Okay? So it's a good idea to have an exit interview. You're going to want to tell them about unemployment compensation. Now, if somebody applies for unemployment, you will be notified by the Department of Labor. And if you think they're not entitled, you have a right to protest. Ultimately, the Labor Department decides. Unemployment compensation is something you pay for. It's part of your payroll costs. And if you have lots of unemployment claims, your costs go up. So it's in your best interest to keep your unemployment claims that are successful low. But the control ultimately is not up to you, it's up to the Department of Labor. Job references. What is your policy on job references? You should have a policy and you should tell them what that policy is. So one policy could be, we don't give references. We will confirm dates of employment. We will confirm what your last pay was. Other than that, no references. Good, bad, and different, 0. So why do you do that? Well, you do that if you're afraid of getting sued. Okay? Your policy might be that you would give references to anybody. Okay. What are the downsides to that? Well,
Bruner,
yes,
I have a question.
yes.
When you say the Department of Labor, you mean the Georgia Department of Labor, right? Or is it a federal?
Georgia Department of Labor handles unemployment compensation claims.
Perfect. Thank you.
So suppose you've got a problem employee, and this employee has been making unwelcome advances, and you've been able to negotiate their departure from your company. Maybe you've paid them severance pay. And maybe in part of your negotiated separation, you've called that a resignation. After all, you just want them out of your work, right? What are you going to do about job references? You better have a policy ahead of time. And this is one reason why companies have a policy of neutral references. We don't say you were a great employee. We don't say you were a bad employee. We just say you worked here. What happens if you don't? Well, that person who is your problem employee goes to work, seeks employment with another company, and you give them a reference that says they were the greatest thing since sliced bread. They were a wonderful employee. And now that person harasses an individual employee at the other company. And the victim sues not only the new company, but sues you because of the reference you gave that was a lie. If it wasn't an actual lie, it was incomplete information and it was misleading. And they got a great lawsuit against you. And because not all terminations are cut and dried, okay, a lot of companies say neutral references. It's up to you to decide what you want to do. But you need to decide what you're going to do. You can't be selective. You can't say, Jill was a wonderful employee. She was here for 20 years. She's great. I want to tell the world she was great. And Jack, who was so-so, not so, going to say, well, our policy is we don't give references. So Jack says, well, how come Jill got references? You need to have policy here. I said at the beginning that some of these rules, some of these laws apply to you if you're a large employer, and some don't apply if you're a small employer. But if you have a grant or if you have a contract, some of these laws will apply to you. Specifically, if you are doing business with the federal or state government, they will typically require you to engage in affirmative action as a condition of government contract. Affirmative action means you're required to take affirmative action to attract, retain, and advance qualified minorities and women. Not only women and minorities, but also you have to have a separate affirmative action program for disabled people. You have to look at your workforce, and you have to look at the external labor force, and you have to see how your representation of minorities or women in your workforce compares with the external labor force. And you do that by job grouping. So a job grouping might be finance managers. And if you have no minorities or women, and the external labor force says 15% minorities and 50% women, then you're underutilized. And if they're underutilized, you have to determine, are there barriers to hiring or promoting women or minorities into those positions? If there are barriers, you have to identify them and remove them. If there are no barriers, you have to set forth goals to remedy the underutilization and a timetable for curing that. And that all goes in a document that's called a written affirmative action plan. It's a big deal. It's a very lengthy, complicated document. And when you're audited, it's a multi-day audit, and it's detailed. The Office of Federal Contract Compliance Program OFCCP is a part of the U.S. Department of Labor, and they routinely audit companies for their compliance with these affirmative action obligations. This applies not just to direct government contractors, it applies to subcontractors. So who is a subcontractor? Who is a government contractor? Well, did you know that the local bank that you do business with is probably a government contractor? You say, well, where does it get money from the government? The requirement that they have insurance for their depositors makes them a government contractor. So if you have a contract with Gulfstream, and Gulfstream is selling airplanes to the federal government, they're a government contractor. You may be a designated subcontractor. So before you decide that none of these things apply, you need to look at the terms of the grant, look at the terms of the contracts, because some of these things may apply and more may be required of you, like written affirmative action plans. Questions?
We have no questions in the chat that have come through yet, but if anyone does have questions, please submit them now.
This is a lot to cover, and I know you haven't absorbed it all.
Are there opportunities for people to reach out to you, Mr. Bruner, if they do have maybe specific questions they don't want to share here?
That's my next slide.
Perfect.
That's me, Bill Bruner, and you can email me at william.bruner@scorevolunteer.org. This is our office in Savannah on Liberty Street. That's the phone number for our office. You can also go on to our website, savannah.score.org, and you can find out all the mentors that are there. You can select a mentor by going there. You can become a SCORE mentor yourself this way. We are free. We help small businesses, including not-for-profit small businesses, and I have several not-for-profit clients as well. But whether you're for-profit or not-for-profit, you still have to make money, right? To achieve your goal, you have to make money, and you have to use the money you have wisely and comply with the applicable laws. And that's where we come in. So by all means, let me know, go to Savannah SCORE, and if we can help you in your organization, we're happy to do so. As I said, it's free, and mentor means we're here for as long as you need us.
That's wonderful. Thank you so much. We've gotten a couple questions asking about getting a copy of this presentation, and I will make sure that the people who attended get a copy of it sent to them.
And if you have, are you going to be sending folks an evaluation?
Yes, they will
like you,
definitely receive a survey.
I'd like you guys to complete the survey. Tell us what you like, tell us what you didn't like, tell us how we can improve for the next set of folks. So we're looking for your honest input.
All right, well, thank you so much. I think that just based on the questions we received and the engagement, I think that this was a very valuable session. I know that you touched on many questions that we've received from agencies, so I really appreciate your time today, and thank you everyone for attending. Please, we will be sending out a survey soon, so please fill that out. That always helps us planning the next presentations. It also helps the individuals who are presenting refine their material, and so we really appreciate that feedback. And if there's no other questions, I hope that everyone just remains safe through our potential tropical storm that we'll have approaching this weekend, and reach out if you have any questions or need any assistance in your Q3 draws. All righty. Thank you, everybody. Take care.